everyone, this is Sakshi Baghel. Welcome to the class. I am an assistant professor of law and today we will be learning about group liability or joint liability under the Indian Penal Code. So, group liability is also referred to as joint liability or constructive liability or vicarious liability, and the concept has been discussed as common intention under section 34 and common object under section 149 of the Indian Penal Code. So, first of all, I want you all to have a look at the definition as it is given in the Indian Penal Code, and then we will talk about the agenda for today. So, first of all, starting from section 34, which talks about common intention, it says that if act is done by several persons in furtherance of common intention, each of such persons is liable for that act in the same manner as if it were done by him alone. Section 149 talks about common object, and it says that every member of unlawful assembly guilty of offence committed in prosecution of common object. Now we will further move on and we will see what is the exact idea behind this and what is the difference between the two. So, the agenda for our learning today is, first of all, what is meant by group liability or joint liability, also referred to as vicarious or constructive liability. Then, why is it actually needed? Where is it defined? What is the idea behind both the common object and the common intention? That is the comparative analysis of both. Then some case laws or judicial pronouncements that we are going to see, and further followed by whether the charges in respect of both the sections can be substituted. So, therefore, we will start with the background of section 34, which talks about common intention. So, the idea behind section 34 is that ordinarily no man can be held responsible for an independent act and wrong committed by another. However, section 34 of the Indian Penal Code makes an exception to this principle, and it lays down the principle of joint or constructive liability in doing of a criminal act. The provision is intended to meet a case in which it may be difficult to distinguish between acts of individual members of a party who act in furtherance of common intention of all, or to prove exactly what role was played by each of them. So, section 34 of the Indian Penal Code originally under 1860 was drafted by Lord Macaulay, and it stood as when a criminal act is done by several persons, each of such person is liable for that act in the same manner as if the act was done by him alone. But later on account of certain observations made by Sir Justice Peacock in the case of Queen versus Gora Chand, it was felt necessary to bring about certain change in the wordings of this section, and accordingly in year 1870 an amendment was brought forth and the words in furtherance of common intention were introduced in the section. So, now if we go through the reading of the section, we could see that how can we actually apply section 34. So, the basic principles are, firstly, criminal act must be done by several persons. Such act must be done in furtherance of common intention of all, and each of such persons is liable for the act in the same manner as if it was done by him alone. Therefore, section 34 incorporates the principle of vicarious liability in the Indian Penal Code. And so, the two requirements that have to be proved for a case to be covered under section 34 will be common intention and participation. Now, it is not necessary that all such persons should be named and identified before the liability under section 34 can be invoked. It should be made clear that once the criminal act and common intention are proved, then by fiction of law, criminal liability of having done that act by each person individually would arise. And thus the section incorporates a rule of evidence and does not create any substantive offence, which is a basic difference between 149 and section 34. 34 is only a rule of evidence. So now let's go through some of the case laws. I'll be talking about some landmark cases which have been decided under section 34, talking about what exactly is this common intention. So the first case that we have is the case of Barendra Kumar Ghosh versus Emperor, also referred to as post office murder case. So in this case, the Judicial Committee had dealt with the scope of section 34, dealing with acts done in furtherance of common intention. It makes all equally liable for the results of acts of others. So the court had commented that they also serve who stand and wait, by which we mean that any accused who is participating in the act, even passively, can be held liable under 34. And so the accused standing as a guard outside was charged under section 302 murder, read with section 34. Next we have the landmark case of Mehboob Shah versus Emperor, wherein the principles of section 34 were laid down by the court, and it was said that common intention within the meaning of section implies a pre-arranged plan, and to convict the accused of the offence applying the section, it should be proved that the criminal act was done in concert pursuant to this pre-arranged plan, and thus intention must be known and shared between the accused. One difference was made between the common intention and similar intention. So the courts had committed that there should not be a confusion between similar intention and common intention. Common intention is something which has to be shared between all the accused. Thereafter we have the case of Kripal Singh versus State of UP, wherein the court was posed with a question, can common intention be developed on the spot? So the court had commented that common intention may develop on the spot as between a number of persons, and this has to be inferred from the act and conduct of the accused and also facts and circumstances of the case. Further, we have the case of Ramaya versus State of Bombay, wherein the courts had said that physical presence is not a sine qua non, not a necessary ingredient for a case to be fallen under section 34. Further, moving on, we will discuss about now what is an unlawful assembly, and by that we will come on to discuss what exactly is the common object that we are talking about in respect to unlawful assembly. So if we go by the definition, first of all, section 141 of the Indian Penal Code defines what is an unlawful assembly. So it lays down 5 kind of acts which will fall under the category of unlawful assembly. So an assembly of 5 or more persons is designated an unlawful assembly if the common object of the persons composing that assembly is, first, to overawe by criminal force or show of criminal force state, central government or parliament or legislature or any public servant in the exercise of lawful power of such public servant. Secondly, if 5 or more of these people resist the execution of any law or any legal process, or they commit any mischief or criminal trespass or any offence, or by use of any criminal force, they take away or obtain the possession of any property or deprive any person of the enjoyment of right of way, use of water or any other right of which he is in possession or enjoyment. Lastly, if these persons are using criminal force to compel any person to do what he is not legally bound to do or to omit to do what he is legally entitled to do, all of these fall under the category of unlawful assembly. So in simpler words, we can say that an assembly of 5 or more people is considered to be an unlawful assembly if they have a common goal of using criminal force to intimidate the government, to resist the law, commit offences, take property forcefully, or coerce someone to act against their legal rights. And by that, we know that under section 143 of the Penal Code, the punishment for unlawful assembly is provided. So, whosoever is the member of unlawful assembly shall be punished with imprisonment of either description for a term which may extend to 6 months, or with fine, or both. And therefore, we have our prime section, that is section 149, which says that every member of unlawful assembly guilty of offence committed in prosecution of common object. So, this incorporates the principle of constructive liability again. It goes like, if an offence is committed by any member of the unlawful assembly in prosecution of the common object of that assembly, or such as the members of that assembly knew to be likely to be committed in prosecution of that object, every person who at the time of committing that offence is a member of the assembly is guilty of that offence. So, mind the words, every person who is a member of that assembly will be guilty of that offence. So, now dissecting the section, we can see that under 149, the commission of an offence must be by any member of the unlawful assembly. And further, it is divided into 2 parts. This offence might be committed by member of unlawful assembly in prosecution of the common object, or the offence such as the members of that assembly knew to be likely to be committed in prosecution of the common object. So, therefore, now what is this common object exactly? What do we understand by common object? So, common object refers to the purpose or a design which is shared by all the members, which may be formed at any stage. It has to be ascertained from the acts and conduct of the individuals concerned and also the surrounding circumstances. The phrase in prosecution of common object means that the offence committed was immediately connected with the common object. Thus, if the unlawful assembly goes with a common object of theft and there, unknown to others, one of the member commits rape, the offence of rape cannot be attributed to all 5. Therefore, coming to the basic ingredients of fulfilling the common object is, first of all, there must be an unlawful assembly. Secondly, commission of offence must be there by any member of the unlawful assembly. And thirdly, such offence must have been committed in prosecution of the common object of the assembly, or it must be such as the members of assembly knew it to be likely to be committed. Thus, if these 3 elements are fulfilled, then only the conviction under section 149 of the IPC may be substantiated and not otherwise. Now, coming on to look at certain case laws in this respect. The first case that we have is the case of Bhimrao versus State of Maharashtra. In that, the court has held, the court refused to hold appellants liable for murder, stating that victim was killed by some of the members of the unlawful assembly who formed a separate common object after entering the house, and so the appellants could be liable only for the common object of causing assault on the victim. The next case that we have is Umesh Singh and another versus State of Bihar. In this case, the case of the accused was to be taken under 149. So, the court had said that accused whose case falls under section 149 cannot take the defence that he did not with his own hand commit the offence for which he is prosecuted. And so, herein in the case, appellants were held liable under 149, and the court had laid down that the prosecution in a case under 149 has to establish Firstly, either the common object of the unlawful assembly or the knowledge of the accused that it was likely to be committed in prosecution of this common object. Thus, there must be a nexus between the common object and the offence committed. Thereafter, let's talk about how and what is the difference between section 34 and section 149. That is, what is the exact difference between common intention and common object? Although they look very similar, what are the grounds that the courts have culled out through various judgments so as to bring out, charge any person, any offender under section 34 read with some other section or under section 149. So let's go through it. First is, if we see section 34, this is not a substantive offence. It is merely a rule of evidence and it has to be read along with some specific offence, along with murder, along with rape or any other offences. But section 149 itself constitutes a distinct offence of unlawful assembly, which is punishable under section 143. Talking about the scope, the wordings of section 34 say that it should be in furtherance of common intention. However, under 149, it should be in prosecution of the common object of the unlawful assembly. Talking about the level of involvement, the courts have said that there has to be some active participation for a charge under 34 to be sustained. This active participation need not be physical. However, the person must be actively involved in the offence. However, under 149, mere membership of an unlawful assembly will give the offence, will hold the person liable for an offence under section 149. Then talking about the number of participants, section 34 does not talk about any such number. It just says that 2 or more persons with common intention committing something can be charged. However, 149 talks about a requirement of minimum 5 persons. At the preparation stage, what is required under section 34 is a pre-arranged plan or a prior meeting of minds, prior concert between the people, so as to develop a common intention for committing any crime. But there is no such requirement in case of section 149. So, lately the courts have faced with the situation wherein the charge under section 149 had to be later on substituted under section 34 because of lack of this minimum requirement of participants. So, the courts have in various cases allowed the substitution of charges. So, looking at the first case, which is Karnail Singh versus State of Punjab. In this case, the court had said that if facts and evidence remains same, the substitution of section 34 for section 149 is merely a procedural matter, merely a formality, and therefore if the evidences remain the same, substitution of charges from 149 and 34 to 34 is very much plausible. Next, we have a latest case of Rohtas and another versus State of Haryana, wherein the question was again with respect to alteration of charge, and so the court had said that charge under 149 can be altered to section 34 of IPC if common intention among the accused is proved. So therefore, we see that courts have come up with this question of charging an accused with either section 149 or if at all a conversion from 149 to section 34 is possible. And in conclusion, we can say that it is very difficult for the courts to determine the intention of a particular person in a group involved in committing an offence. And in such cases, the principle of joint liability is applied. And judges must have a keener eye in order to separate this grain from the chaff. So that is about the common intention and common object. I hope you have learned something fruitful from this. So that is all from my side and in the today's class. We'll all meet in the next class with a new topic. Until then, goodbye. much.